Welcome in, Clark County. I'm Rob Anderson with Reform Clark County, and this week marks the one-year anniversary of the Belkot removal scandal, an event that triggered lawsuits, criminal investigations, and now the famous Skamania report, a report that mysteriously still hasn't been forwarded to another prosecutor. And now, 1 year later, the same officials involved are rewriting the rules to give themselves the authority they never had. So today we're going to walk through what actually happened and what they are trying to hide now, because the story Clark County residents were told is not the whole story. But before we jump in, hit the like, the share, the notification, subscribe, whatever you got there, and consider supporting the show in effort to reform Clark County, which gives you a closer look at what's happening in Clark County. So I thought we'd look back on this episode and commemorate one of Clark County's finest examples of corruption and how some things really get done around here. 1 year ago, on March 11th, 2025, the C-TRAN board was preparing to vote on a proposal that would prohibit, future operation and maintenance funding for light rail. I mean, right before the vote, Mayor Ann asked the councilors and the representatives to kind of share their voting intentions. And after counting the votes, it became really clear that Councilor Belkot would be the deciding vote, and Mayor Ann's train for Vancouver was going to be in serious jeopardy. But the next move didn't come from Mayor Ann. In a seemingly choreographed move, it came from her Democrat ally, Sue Marshall, who promptly made a motion to table the Belkot motion, which would stop it.
Then to not go with the directive that was given to you by your colleagues in that 4-1 vote?
There was no direction for me individually or specifically, and I've checked in about this.
The direction was provided by the county council, the majority of the county council.
There's nothing in our bylaws that would prohibit me from voting.
Chair, I move to table this item.
I second the motion.
So the light rail project, could have been stopped that night. On March 11th, we could have said, that's when light rail dead and buried for now in Clark County. But that didn't happen. Now, what did happen next hasn't been made public. This is the first time this is coming out into the open. Through discovery processes, public records request, and a little maneuvering, I obtained a text message that Sue Marshall withheld and possibly committed perjury to keep it private, sent shortly after that March 11th C-TRAN meeting. So at 8:45 p.m., roughly right around there, the C-TRAN board ends. And then just a few hours later, this text message arrives at 11:11 p.m. that night before Belkot was removed. And this is the first time anyone's seeing this. Sue Marshall messaged Councilor Matt Little, "Can we check in before council time? Thanks." Now, that seems harmless, right? That doesn't sound like a big deal, except for one problem. Marshall later signed a sworn affidavit under penalty of perjury claiming she had turned over all of her text messages, which she did turn over some, including a text message from Troy McCoy, who has recently announced that he's running for D5 County Council with Sue Marshall's endorsement, and if elected will certainly continue where Sue Marshall left off. But she never turned over this text message that she sent to Councilor Little the night right after the C-TRAN meeting. She hung on to it, pretended it didn't exist, kept it from discovery, kept it from public records. So the only reason it surfaced is because Matt Little turned it in after the county's own attorney warned the councilors that, missing records, that'd be a serious problem. So the question becomes simple. Why hide this text message? I only received this text message because during a conference call a few days before the preliminary injunction hearing with the county's attorney, Paul Lawrence, I told him I believe some of his clients, maybe Marshall, Young, Fuentes, or Little, had not turned over all the relevant records from their personal devices. And he agreed this would be, a real problem. So Mr. Lawrence informed his clients. I know this because I later filed a public records request. Yes, I'm that kind of a guy. And regarding these text messages and in the responses, there was an email Lawrence sent to Marshall, Young, Fuentes, and Little, and I couldn't see the full comments because it was redacted. But because I received these records, I know that it was connected. And shortly afterward, Matt Little, to his credit, turned over the text message, a text message that Sue Marshall still hasn't produced. And here's why this matters. First, Sue Marshall appears to have perjured herself by signing a sworn affidavit stating she had turned over all the texts from her personal devices when she hadn't. A text message she apparently wanted to hide from the public and from the courts. Second, if 3 counselors discuss a public business, outside of a public meeting, that's a violation of the Open Public Meetings Act. Yet Marshall, reached out to Little at 11:11 p.m. on March 11th. Belkot would be removed the very next day. If evidence shows Marshall discussed the decision with other counselors, as the communications suggest, that would be a strong evidence of an OPMA violation and go against her signed sworn declaration that was submitted to the court in her affidavit that she signed regarding the earlier public records request that I submitted. So let's take a closer look at this, shall we? Because the next day, March 12th, just hours before they would act to remove Belkot, at 10:19, Sue Marshall sends Glenn Young a text, "Can you call me if you have a minute?" But that wasn't enough for Sue because at 11:41 on the same day, March 12th, she emailed Councilor Young a link to the C-TRAN meeting from the night before, clearly connecting this to the Belkot situation. But with just less than an hour before council time, Marshall sent another email. This time at 12:01, she wrote, "Let me know if you want to chat." Now, did I mention that it was Glenn Young who first brought up the desire to have Belkot removed?
So quite frankly, in my opinion, if we have a counselor that is not willing to reflect the will of the council as a whole, they need to be relieved of that position and somebody else placed in it that will represent the council as a whole.
Now, I know if counselors had, cooperated with the detective's investigation and sat down for interviews, each of them would have likely have been, asked the same question. Hey, did you talk as requested? And what did you guys talk about? Now, in a declaration, Sue Marshall, said that she hadn't even communicated with counselors. When emails prove Sue Marshall sent a link to the C-TRAN meeting and 2 requests to talk. But in a sworn declaration, she stated, "I did not discuss or communicate about the removing Councilor Belkot from the C-TRAN board with any other counselor until we discussed it in the March 12th, 2025 meeting." The evidence strongly suggests they did. So Sue reached out to Glenn Young several times. That might not be a big problem. But when she reached out to Matt Little, and maybe why she didn't share the text message, that would be a total of 3 counselors. Not to mention Will Fuentes, who seemingly, came to the council time meeting with a prepared motion to remove. But we'll get to that at another time. So what this all means is this would be a serial communication violation under the OPMA, making a decision, outside a public meeting, in plain English. They made the decision behind closed doors. And the Skamania report detective commented that after reviewing the meeting, after he watched this meeting, it seemed obvious that the decision had already been made because of the lack of discussion that took place. It's something so controversial. Is this why Prosecutor Tony Gulick is, helping the Skamania report disappear? Because what happened next at the council time at 1 p.m. meeting on March 12th, 2025, as we come to the 1-year anniversary, triggered public outrage, lawsuits, criminal investigations, and fundamentally really changed the course of Clark County transportation policy. Instead of, light rail being effectively stopped, saving taxpayers millions, maybe billions, Sue Marshall pushed it forward to remove Belkot, a move that, according to the evidence, may have involved knowingly violating OPMA. But that wasn't the only issue. The Skamania detective detailed further actions at the March 12th council meeting, removing Belkot from the C-TRAN board, that this was not listed on the agenda. And under OPMA, final actions must appear on the agenda so the public is informed and allowed to give comment. But because the council time comments are limited to agenda items only, the public had no opportunity to weigh in. They kept it off the agenda, and so no comments were made. None of the councilors moved to amend the agenda, yet some of them knew this was coming. Marshall, Young, and Fuentes remained silent, but they knew this was coming.
Okay, are there any amendments to the agenda? I have a couple of amendments to the agenda. Removal of 9.4 under executive sessions and adding 9.6.
The public was never notified, and the vote happened. But the Skamania investigation found even more potential violations. The Clark County Charter does not grant the council authority to remove board appointments. They simply invented that authority, and now, nearly 1 year later, almost on the anniversary, they are attempting to rewrite their rules and procedures to create removal powers that they didn't have or exist. The charter is clear. Under Section 3.3, the county manager has the power to nominate committee members. The council only has the power to approve or reject nominations besides just a small number of boards, and the C-TRAN board is not one of them. But instead, the council itself nominated Will Fuentes to replace Belkot on the C-TRAN board. Power of the charter does not grant them. The Skamania detective was also investigating whether councilors conspired to violate the law, whether they knowingly coordinated to circumvent the OPMA and the charter. But the county manager and councilors Marshall and Young, Fuentes and Little never sat down for interviews. So we might not ever know the truth on that. And now Prosecutor Tony Gulick has still not forwarded, the report to another prosecuting agency. Instead, he first contacted his buddy, Nick Brown, who is now the Attorney General's office, who happened to be a former partner at Pacifica Law Group, the same law firm representing the counselors. So Tony Gulick hired Pacifica Law Firm to represent the counselors in the federal lawsuit and against my complaint. Pacifica Law Group represented the 4 counselors. Nick Brown was a partner there. Now Brown is the Attorney General, and his office to decline the review, even to read the Skamania report. Nothing to see here, I'm sure, right? Nothing to see. So as we mark the 1-year anniversary, remember the lengths some elected officials will go to, push a project like light rail, something like, Clark County voters rejected by 56% in a county measure. They'll violate the state law, ignore county charter, refuse interviews, file seemingly false affidavits and declarations in court and to the public. And in a criminal investigation report, just let that quietly disappear. But this story isn't over because there is still more evidence to come. including potential perjury in court declarations by none other than Councilor Will Fuentes. Yes, this is the gift that keeps on giving. Stay tuned. So that's Reformcast this week. Please hit the like, the share, subscribe buttons, whatever you need to do to get more updates. Don't forget to do that. And if you like the show, find it helpful, helps you to stay engaged, you can support my efforts here. Even just $10, $20 a month helps, goes a long way. And you could do so by going to Give, Send, Go at Reform Clark County. If you have questions or tips or topics you'd like me to investigate, email me at rob@reformclarkcounty.com. And remember, with God's help, you are the catalyst of reform. See you next time. That's a wrap.